familiar with your clock in your rebuttal time.
Will you come on? And I do believe it's in a different. I can actually see. So.
All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All we have cause to plead. Draw near, give attention, and you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on the court's docket today is the Florida Bar versus Anderson. Counsel?
May it please the court, my name is Chris Altenburn. I'm a member of the Banker Lopez Gassler Law Firm, and I'm here today representing the Florida Bar. Ms. Anderson has filed a cross-review in this proceeding challenging some of the findings of guilt, and so I'm going to try to use about 8 minutes of my time addressing the appropriate sanction up front and save the rest of my time for my response and my rebuttal.
Mr. Altenburn, could you speak up a little bit? I think my audio here is not really working great. So.
And I'm terrible about not speaking loud enough, so I will do that. This court knows that case number 18-1646 is still pending in this case, in this court. In brief recap, in that case, the parties are undisputed about 28 violations, most of which are trust account violations. And Ms. Anderson is arguing that she should receive in that case a 3-year suspension followed by 5 years probation, and the bar is seeking a disbarment with leave to reapply within 5 years. It was the bar's position that it obtained an emergency suspension because of great public harm, that Ms. Anderson had written a check for a real estate closing that was dishonored, and as a result of a shortfall in one of her trust accounts of $120,000. As a result of that, the bank was never paid what it was due at the closing. But in this case, the 28 violations become a feature of what should be the appropriate sanction here. Because as you know, the referee has recommended to you a public reprimand. But the referee took the position that because this court had not yet entered its final judgment in this case of first instance that was in front of it, that he would not in any way want to know anything about it or use it as a factor. He said he was persistent about that. So the recommendation comes to you from a referee who has not factored into the mitigating, aggravating balance 28 violations that even Ms. Anderson agrees should at least warrant a 3-year suspension. Now, the bar submits that if you treat these cases in series and that you enter your judgment first in 18-1646, that at that point in time, there are prior violations that you can and you should use to balance what the proper sanction should be in case number 19-1340. And if you do that, it's our recommendation based on the prior cases that you impose a 1-year suspension. We make that recommendation based upon the admittedly non-precedential decision in the Murtha case a couple of years ago where you gave a 1-year suspension under somewhat similar circumstances. Now, I don't have enough time in this case to go through all of the facts, but the core facts here relate to 2 emails that were sent on October 18 and on October 19. Ms. Sotia had come to what appeared to her to be a 20-person law firm on the 15th floor of a building in Orlando to seek advice about how to transfer a piece of property. She thought she was going to see a Mr. Simon, but she ended up being put into a room for an attorney-client privilege with privileged conversation with Ms. Anderson. Ms. Anderson handled the credit card transaction, gave her a business card from Orlando Legal, and explained to her that they would have to file a probate proceeding in order to be able to transfer this piece of property because her father had died and that impacted title. So Miss Sotia left with the impression that that was what's going to happen. She heard nothing in 10 weeks. She sent an email, and that email, of course, came 10 days after this court's emergency suspension in the first case, and a couple days after the standard letter that the bar sends out explaining what you do when you're in an emergency suspension situation. That email, in critical part, says, I believe the last time we spoke, you were going to submit the paperwork to the court as my dad's portion of the house needed to be allocated to my mom. What's the next step? Now, it's Miss Anderson's position that when she received that, it was her belief that they were not in an attorney-client relationship. Now, if that were the case, I would think she would have immediately responded, hey, there's some mistake here. I was just covering for this Mr. Simon fellow. He's your lawyer. Admittedly, he's got some problems with the bar right now, but you need to get in contact with him to make sure he does this because I can't do this for you. But that's not what she does. She waits a day and files a cheery email back. Hello, I have followed up with the comptroller and apologize for the delay. Now, we know for a fact from her email to her staff a month earlier saying we don't want to speak this man's name again, that she knew that the money was gone from the operating account a month earlier. So she didn't need to check with the comptroller about anything before she sent back this email.
Those I agree, are significant facts. What do you make, or what is the bar's response to, let's call it the atmospherics around this? The fact that at the time she is having contact with other clients, per the bar's order, that she seems restricted in what she knows about the denouement of Orlando Legal, and it seems to be cratering, and she's not sure what she can say. How does the bar respond to those atmospheric concerns? Are they extenuating in the bar's view at all?
The referee, I think, found to some extent that that was a mitigating circumstance. We're not challenging that. But keep in mind that she is receiving an email from someone who obviously thinks she's her lawyer. And she's in a spot where she knows at that point she's got 20 days to close it all down and make sure that anyone who is her client has landed safely with someone else who can finish the work. And instead, she sends this email that reconfirms that the Ms. Sotillo's belief. She even gives her a new email for going forward, promises her she'll work the weekend, and that she will then upload the balance of the documents to the portal. It's the last communication she ever has with this woman. The referee finds that she abandoned this woman. And, frankly, if she'd responded right away and say, hey, I'm not your lawyer, this would probably be a very different case. But instead, she does this. And the referee found that this was deceptive, that it was something that was contrary to honesty and justice and a violation of 3-4.3. And by the way, in the first case, there was also a violation of 3-4.3. This is the second time she's had someone proposing a violation for dishonesty. And I submit to you that when you read through this, the referees find it is clearly supported by competent substantial evidence for all of these things. If you're going to say what is in this email, and you can read through it yourself, there are lots of things more you need to explain about where Mr. Simon is and where the problems are and where the money is, and I can only help you for another 20 days, and none of that is here. That's the problem. And that's what was the core of these violations. Frankly, the violation of 3-5.1H for not sending the suspension order is kind of the tail of the dog, because that would have come part and parcel with the communication issues that didn't take place here. Now, standard 7.1 says that a knowing violation is something that warrants a suspension. And I'm running out of time, so I'm going to tell you that the Murtha case is very similar, because it's someone who got a 91-day suspension for a trust account situation that didn't cause a penny's loss to a client, much less 120,000 days. And Mr. Murtha is sloppy. He didn't manage to notify 3 of the judges, and this court gave him a 1-year suspension. I submit that the facts here are worse than that, and that this case would warrant that. Now, frankly, this court does not typically impose a one-year suspension consecutive to a 3-year suspension. It's not like criminal sentencing. And so I suggested as a practical matter that I think it's simpler to just treat this as 33 combined violations. The 28 then become multiple offenses rather than prior offenses in the analysis, and that ought to move the needle in the first case to the point where a disbarment with leave to reapply in 5 years would be appropriate. So that, frankly, would be my suggestion as a practical solution to this. I'll reserve the 5 minutes and 30 seconds. Thank you.
You. Counsel?
May it please the court. David Rothman, Rothman Associates, on behalf of Elizabeth Anderson, my pleasure to appear before this court. I take note, as I expected, that the bar once again will begin their argument with the negligent trust case and attempt to sway the court as to what they were seeking from day one on that case, which is disbarment. And I remember reading the transcript that Justice Lawson challenged the bar and said, but you never appealed on that issue, did you? And of course they had to say no. So this is their second bite at the apple from their perspective. That's inappropriate. If this new case, the case we're in front of the court on now, if this case were a standalone, what would have happened is the bar would have offered Liz diversion. There was no harm. What the bar is trying to make it sound like this conceived plot by Liz Anderson was a meeting on July 31st, 2018, which she wasn't supposed to take. It was a meeting for the owner of Orlando Legal, but he was unavailable. She's an independent contractor. They reached out to her from staff to go to this meeting having no idea except it's something about a real estate matter, which really wasn't a real estate matter, it was a probate matter, which she knows nothing about. She goes...
Well, but counsel, that's just inconsistent with the way she subsequently responded to the email. I mean, if that were true, and you accept that as true, then the response is, I'm sorry, I'm not your lawyer. You need to get somebody else, rather than I'm going to take care of it quick.
But
what
why...
am I missing when I...
I agree with Your Honor, and we've conceded in our papers, and I'll concede here today. Today, I would tell her, don't throw that pass. It's going to be intercepted. We can do that in cases. You can do it in every case. But at the time, remember what's going on. It's a short meeting. She's trying to gather information, has no idea what this is about. She's not being hired. The law firm is. She's
I'm
not
not
being
talking...
paid.
The focus is not
Can I
on
get
that
there?
meeting.
Can I get there?
Excuse me.
I'm sorry, Judge.
The focus is not on that meeting, okay? We'll accept your... even if we accept your version of what happened there, it's about what happened subsequently with those emails. And everything you say might be true about that meeting, but that does not explain. As a matter of fact, it's in conflict with what happened later.
And I'll tell you why it's not.
Okay.
The total sum of her contact with Ms. Sotillo was the 20-minute or so meeting that she wasn't aware of and that she dealt with. Then what she did, that was July 31st. In August, as part of her being an independent contractor and having information, she drafted, unbeknownst to Ms. Sotillo, she drafted a petition using her own research to do that. And it was missing two things because Ms. Sotillo wouldn't give her the names of her siblings, which had to be included in the petition. So she prepares the document. She then does what she's supposed to do. In August, she turns the document over to Jonathan. She sends it, she uploads it into the portal, which she refers to in that email. That's in August. In September, she confirms with staff that Jonathan has the document, he's working on it, and he's going to take over and take care of the whole problem. Then out of the blue, Ms. Sotillo emails not Jonathan, who she hired, but Liz, because that's who she had contact with.
You said who she hired. Can we talk about the economics of the engagement for just a second? Who processes the client's payment on July 31st?
Well, when we
Is
say
it Ms.
process-
Anderson?
When we say process, the staff does that.
Okay, obviously. Who takes her credit card? Who says this is the amount that's due? Is it Ms. Anderson who's having that conversation?
She didn't set the fee. The fee was with the firm.
I understand. Who asks for payment? Do you concede that Ms. Anderson, I'll put it to you this way, that no other lawyer on July 31st was involved in taking payment from this client? Is that right?
That's correct.
Okay. And the fee is paid up front, right? Whatever, it was
My
$2,000.
understanding was it was a $100 fee that was paid before she came to the meeting.
That's right. But then what happens with I remember that there was was it a fixed fee? It was like a $2,800 fixed fee for the engagement?
Something like that, yes.
And is that paid on July 31st as well?
Yes,
And you're saying Ms. Anderson didn't set that fee?
correct.
Okay. But it's collected. So this is a fixed fee engagement, and it's paid up front. And are there no subsequent communications with Ms. Sotillo over the next 10 weeks?
From Liz? No, she
Okay.
had no contact.
So just to put myself in the shoes of the client, on July 31st, I walk into a law firm. I wait for a long time. They ask me for $100. I give it to them. Then, before the conclusion of the meeting, they ask me for $2,800, which I'm charged. Then 10 weeks go by, and I hear nothing from anybody at this law firm, having paid up front for for a solution to my legal problem. That's not a good fact pattern, is it?
No, it's bad. It's bad. And we've conceded that. But remember, though, when Liz walks out of that room, she knows that Jonathan's the lawyer. She knows. I agree with every concept that from the client's perspective, it's a different perspective. And for that, she failed to follow up enough. But she didn't do anything that violates the rules. She gave the file back to the firm for the lawyer to take care of. She confirmed it. She was not diligent. She was diligent. She actually prepared the draft. She gave the draft to the lawyer who was hired. Remember, there's a fee agreement signed with Orlando Legal. She is not Orlando Legal. She's Liz. So you have that one issue. Yes, she could have done better, which is why in our papers we're conceding that in this case, if you think it's appropriate, and the problem is the bar's arguing that the negligent trust case should be a more significant sanction because of this case, and this case should be a more significant sanction because of the negligent trust case. But let me point this one factor out. By your order, Liz Anderson was suspended from the practice of law 3 years and 4 months ago. She's been suspended for 3 years and 4 months ago. Assuming best case scenario that you give us what we're asking for, that you leave and you give her the 3-year suspension and you give her a public reprimand on this case. You don't need to combine the two cases. That's a pretty obvious non-combination. But your order comes out in about, say, 4 months, 5 months from now. Then, assuming you give us what we want, best case scenario, she has to apply a reinstatement. That process requires that she prove rehabilitation, including paying the money that the bar references that's due, which she's going to do before she gets admitted, of course. She sold her house to do that, by the way, and then she had to use that for lawyers' fees because of the new case. Assume you do that. Then what happens is it takes 6 months for reinstatement. So your emergency suspension of her, that's the time it's going to take if you do what I'm asking you to do. She will have been suspended for 4 years before she can be readmitted. What the heck's the point of going past that? What really is necessary? Effectively, she's getting a year for this case. That's effectively what's happened. And anything more than that, and we agree she should have done better. We agree that the client was slightly harmed, but if you look at the harm to the client, thank goodness that Warren Lizzie represented her and told Ms. Sotillo, get your money back, and she did, and used that money for the new lawyer. So the harm was 3 months. Miss Sotillo didn't even start to get a lawyer for 2 years after her father passed away. So it's not like it was an urgent thing. It wasn't litigation.
Let me ask you this. Would it be appropriate to consider the cases together or consolidate them and have one sanction? And if not, why not?
I think that's an exceptional situation which you don't have here. There's no continuing pattern here. You have the case where the bar's talking about the number of violations. They're all negligent violations, and there was never a challenge to that. So I don't care how many violations you've got. If it's a result of negligence and she's going to fix the harm, then it's negligence. It doesn't get beyond because there's 27 technical violations. There's separate cases involving the same rules. That's how they get 27 violations. It's not 27 different violations. It's just a different number of cases, and then you have 6 or 7 each case. It's simple math, but it's not really. So the point is, it's negligence.
Let me ask you this: if we did consider them together, I've heard what you think the sanctions should be, and an explanation for that if they're treated separately. But if they're treated together, what's the appropriate sanction? And tie your answer to our case law and the findings that were made in both cases, those that are favorable and those that are not favorable. So.
I would suggest what the court does is it should be the 3-year suspension with a public reprimand with the 5 years probation. So you would combine it, and you would also publicly reprimand her in addition to the 3-year suspension for this case. That's what I suggest. If you want to suspend her for
tie that to our case law as opposed to disbarment. So
there's no case law. There's no case law as to this case. That's the problem. What you're looking at, and I'm not fathoming this at all, but the bar is making this sound like she connived her way through this whole case when she did way more than anybody I've ever seen and get in trouble for it. And the bar has no case, not a one case they've shown that what she did in terms of trying to reach Melissa Mara, who's a wonderful person who's been maligned. Wonderful. We rely on her as a respondent's counsel. Wonderful person. Told her, do not have any contact with Ms. Sotillo. And she did that. So she would have been better off not to have any contact at all, not to have done the probate petition, not to have met with the woman, not even to take those 2 emails. This whole matter is a personal meeting, an unexpected email from Ms. Sotillo, and Liz's response back. That's what this whole case is. There is no other relationship.
the more serious violations are obviously in the first case.
Yes.
And so, I know we've had argument on that case, but I'm asking about the case in general. For negligent trust violations, talk about our case law and suspension versus...
to a 4-year suspension, non-pro-tunc. Give her a 4-year suspension, non-pro-tunc.
I'm asking about our case law. If you tie your argument
There is no,
to...
there's no, Murtha, they're relying upon Murtha. In Murtha, what he did was, he lied to the Supreme Court. He lied to the bar. He said, I notified these 3 judges when he didn't. How could that case match this, where she contacted the bar? She tried 3 times. Her paralegal tried to contact her. They finally reached her, and she was told not to have contact with Ms. Sotillo. How does Murtha in any way reflect what happened here? She did everything she was supposed to do. Could she have done more? Absolutely. But is that the test? Should that be the test? That really isn't fair. It isn't fair. It's just not fair. And I know you, as a court, it makes sense to try and combine these into a single sanction, but it's sort of mixing apples and oranges. If you're looking to disbar her, you could have done that with a 3-year suspension on a negligent case. I've not seen disbarment on a negligent case before. I know this court's getting tougher, and you say that, and we, Respondents' Counsel, the bar, and they know that. We all know that. But you're also fair. And I think this case calls for the equities. I have a little bit of time left for rebuttal, and I'll discuss some of those equities in rebuttal. Thank you.
Counsel, before you get started, can I ask you a quick question?
Yes.
Is your colleague on the other side right that if a 3-year suspension were imposed in the other case, that it would essentially sort of backdate to the emergency suspension, or would it be 3 years going forward?
This court has a lot of discretion on what it does, but retroactive implication of a suspension or disbarment. Very rare thing for you to do. And since the creation of the Florida rules of professional conduct, you've done that very, very rarely, typically with felony.
So the fact
So
that it was in a...
it would be an aberration, but you clearly have the power to do something that ran this from an earlier point in time.
So
if you wish.
the fact that there was already an emergency suspension doesn't, under our case law, doesn't mean that she would get credit for that time, because obviously his argument, what he's presenting, is premised on the idea that
Right.
it's a 4-year thing, but really it could be a 6+ year thing.
That is correct. The way this system works, that absent a consent judgment that where they agree to run things earlier, especially with an emergency suspension, it normally comes down and starts when the judgment is entered by this court, and it does take a long time.
Well, if that's true, and if there's a 3-year suspension in the first one, hypothetically, or if she's already been suspended for 3 years, and if there's another 3 years, I mean, is it the bars? I understand that it would be, a function of kind of logistics and not sort of a statement about what would have been right if we'd had a crystal ball and everything. But is it the bar's position that essentially her being, out of action for 6+ years isn't enough for the two cases combined?
A couple comments on that. First, that's one of those things, if you start doing, everyone's going to argue that for you. And you've got, not only are you to be fair to her, but you need to protect the public, and you need to have a deterrent factor. And so if you start doing those things, it impacts the other two portions of this. And keep in mind that this is kind of a combination of the two most extraordinary forms of disciplinary proceedings that we have, because this is an emergency suspension, number one, because of great harm to the public, because, okay, it was negligent accounting, but it was so negligent that two CPAs couldn't put it back together.
Right.
And so that was a big deal. And then
I'm sorry to interrupt you, but your colleague on the other side said this a couple of times, and I didn't. It felt like a mischaracterization of what you were saying the first time. This idea that this was some sort of kind of preconceived plot or something on the part of the attorney here. I don't hear you. I mean, it sounds like there's obviously, you guys have different views as to how to characterize the first case, but as far as this thing with the email and everything, I mean, even your position on that is that it was that it was a violation, but that it wasn't sort of the culmination of some preconceived desire to harm anyone. I mean, it seems like it was maybe she shouldn't have responded to the email the way she did. But you know what I'm saying? So
yeah,
in terms of deterrence,
if you're asking me, do I think Ms. Anderson is an evil person? No.
Well, he didn't say that, but
I'm just going to say, what the difficulty here is that we have a case where this is the second time that a referee has found a 3-4.3 violation for something that is contrary to honesty and justice, that she was dishonest in both of those things. And that makes it harder. I mean, I understand exactly what you're going through, because I've gone through the same thing thinking about this case, but the combined dishonesties in this case, coupled with her motivation and why she did the second part of this, is by clear and convincing evidence not really established. I don't really understand why she did that. But it just is very strange that she sent the cheerful email if she really believes she wasn't the lawyer, and it's another 10, 12 days before she talks to the bar to think through, well, gee, maybe I really need to tell her she needs to find another lawyer, and all that time, and none of that happens. So I've only got a minute left, and I only want to mention one thing, and that's about Ms. Mara and the basic arguments about her. Contact with Ms. Mara was on November 5th, 2 days before she was suspended. At that point in time, realistically, there was nothing left that she could do for this client. And all of these arguments they've made through in the referee and in the briefing, that this is all Ms. Mara's fault, and we should be bound by that. But the decision she was making were decisions back on October 19th and 20th and so, and that is completely unrelated to Ms. Mara. What concerns me is the referee found that she showed remorse, and she did say she was remorseful, but I see nothing in the record that shows that she was remorseful about sending this email and further confusing and abandoning a client. The dishonesty, there's no showing that she's remorseful for dishonesty. Instead, what she's tried to do is shift this to the point where it's really all Ms. Mara's fault. She's used Ms. Mara as a scapegoat, and that just doesn't seem like remorse to me in this. So my time is up, unless there are any additional questions. Thank you.
Thank you. Mr. Rothman.
Now they're accusing Liz of additional violations. The fact of the matter is the bar in its opening brief said that Liz should not have relied upon Miss Mara because she wasn't a lawyer. Remember reading that? That's what they said. That's putting down Melissa Mara, putting down the bar. Here I am arguing in favor of the bar. The point of this is she had to follow that information. She had to follow that directive. There really is no violation, and in fact, the bar finally came to its senses at the very end and conceded that the bar can't prove that by clear and convincing evidence. They said that. But what's really more important, and this is a little bit disingenuous, the referee found as a mitigating factor lack of dishonest or selfish motive. Lack of dishonest or selfish motive, and they're arguing that she manipulated, lied, and cheated, essentially, when the referee made that finding. And that's inappropriate, and that's not fair. Do you want to combine the sanctions? Obviously, if you want to, do it, but don't make this more. Don't make that case, that's no case, more. Ask yourselves, why would she not notify Ms. Sotillo when she notified 16 other clients that she'd been suspended? And then they made the ridiculous argument that immediately means she has to do it immediately. And it doesn't matter that she couldn't reach Melissa Mara the 3 times they tried, and then finally with her paralegal the 4th time they did. But that shouldn't matter. When she's told by Warren Lindsay, I would tell him the same thing, by the bar, if you have a question about 3-5.1, call Melissa Mara. She's still in that same position as well as she should be, but now because of this case, where Melissa had no notes from this case, every communication has to be by email. So from this case came a fix that's going to make it better, so no one's going to be put in Liz's position again. She did everything she was supposed to do. This is sort of like the bar trying to turn a silk purse back into a sow's ear. That's what's happening here. That's not fair.
All right. We thank you for your arguments. The court will now proceed to take up the case of Tribeca Asset Management versus Ancla International.
Good morning, Your Honors. May it please the Court, my name is Rebecca Plasencia of Holland & Knight, and together with my partner, Adolfo Jimenez, we represent the petitioner, Tribeca Asset Management. I'd like to reserve 4 minutes for rebuttal. Your Honors, we're before the Court today on an opinion from the 3rd District Court of Appeal that holds that a plain and unambiguous choice of law provision can be converted into a form selection clause to confer personal jurisdiction over an objecting defendant without any further analysis as to whether due process is satisfied. And therein lies the source of this Court's conflict jurisdiction, because the 3rd DCA's opinion is in express and direct conflict with decisions out of the 4th DCA, the Hamilton versus Hamilton and the Ware versus Citrix Systems cases, that hold that even if you have a form selection or consent to jurisdiction clause, which we don't have here, but even if you did, you still have to undergo a due process analysis. Second, the third DCA's opinion conflicts with clear law in Florida that a choice of law provision by itself cannot confer personal jurisdiction. And we filed a notice of supplemental authority of a Burke Products versus Access Electronics case, second DCA, that also stands for that proposition. Finally, the third DCA has determined that this clause, which does not specifically refer to where the seat of arbitration will take place, is a form selection clause, when the very definition of a form selection clause is that it selects a form. It identifies a form in which these disputes are going to be resolved. So for all these reasons, this court does have jurisdiction. And now on to the merits. The third DCA opinion has to be quashed. The interpretation of this contract in this case violates the plain and unambiguous language of the contract. And it creates a dangerous precedent because it's basically creating a jurisdictional hook from a choice of law clause when that is not the law. If we do not actually select a forum, if you do not actually consent to jurisdiction in a particular forum, that is not enough to confer personal jurisdiction over an objecting defendant. Nowhere in our jurisprudence is there a case that holds that a choice of law provision by itself is sufficient to confer personal jurisdiction. What we have is a provision that says this agreement shall be governed by the laws of the state of Florida. Now, 3 sentences follow this choice of law clause, dealing with how to handle any differences that arise. And the 4th sentence following this clause, 4 sentences after the choice of law provision, says, and if you can't resolve your disputes, we'll resolve them in an arbitration board.
Counsel, I'm sorry to interrupt you. So assuming we agree with you on that, what would be the right thing for us to do at that point?
To quash the third DCA's decision and to reinstate the trial court's decision, because the trial court said there's no venue.
And just stop the analysis at that.
You stop the analysis at that point, because if you don't have a form selection clause or a consent to jurisdiction clause, that's it, it's over.
So we don't need to get into
You don't.
the other stuff.
You just reinstate the trial court's decision and the case is over.
Okay.
Now, the greater question, of course, is what if you do have a valid form selection clause or a consent to jurisdiction clause? And we're not saying that you can't contractually agree to that. If you've got 2 parties who have signed an agreement, who have voluntarily, with informed consent, entered into this, that's a different story. You still have to do a due process analysis because that's what the law says. Even Section 685.102, even when the Florida legislature said, we're going to create a jurisdictional hook that parties can agree by contract, it still says you can't violate the U.S. Constitution. There still has to be some due process analysis, contained. And what the third DCA did here, besides improperly converting this into a form selection clause, they didn't even bother with the fact that it was undisputed that Tribeca had no minimum contacts with the forum. In addition to the fact Tribeca isn't even a signatory, so we didn't even get to the first issue as to whether this was a freely negotiated clause between these parties, because Tribeca wasn't a signatory. That itself would have to be established before you can then go into an analysis of the due process. So to be frank, the third DCA just tortured this clause to create a form selection clause where none existed. And frankly, Your Honor, I think it's a pretty clear case based on the plain and unambiguous language of the contract. Unless this court has further questions, I'll reserve the rest of my time for rebuttal.
May it please the court, Carlos Sardi on behalf of ANCLA International SA. It's a pleasure to be before you for the very first time, and I feel very welcome. Thank you so much. Let's get now to the argument here for a second. It appears that, or at least it seems to me, that what Tribeca is intending to do before you here today is to have an appeal all over again of what the third DCA already determined. Essentially, its own factual de novo interpretation of this contractual language. Their so-called conflict, it's non-existent. We are not traveling under the long-arm statute. We're not traveling even under the Chapter 685 statute or body of law regarding generally contracts, we're traveling under a very specific statute, very much favored by this court in terms of arbitration and the arbitrability of cases in which parties have negotiated freely and voluntarily to arbitrate a matter. This is precisely what happened in this case. In the court below, there were a couple of conflicting affidavits, both of which were weighed and under which the trial court erroneously took the position that only one of the affidavits held the truth, position on a dismissal. So I want you to keep in mind that dismissal of this case had already been heard at the first instance, and an order denying that dismissal. Second time upon which the court heard dismissal was just at the heels of an evidentiary hearing upon which the petition to compel was going to be heard by the court with evidence that both parties were ready and prepared to put on forward. So court cut off that hearing, essentially taking a position that it could rule on summary judgment, essentially, and try to dispose of the personal jurisdiction issue which had been preserved by way of an affirmative defense, and at that time, without any evidence, contradicting affidavits, ruled on the personal jurisdiction, committing an extensive error by having done so and not allowing evidence to come forward. Despite that, the third DCA correctly took a review, a de novo review, and decided on a de novo review that when you take a look at the particular clause here, which is extensive, looks extensive in nature, 144 words, my esteemed opponent only looks at 13 of those words to make her arguments, whereas the third DCA, in correctly interpreting that particular contractual provision, took a look at the whole provision to try to give it meaning, to see what the parties actually had agreed. What my esteemed opponent is saying is basically disregard the portion of that agreement that reads, a jurisdiction accepted by the parties.
Well, but counsel, I mean, the language starts off, obviously we have to look at this all in context, right?
Understood.
We concede that. But it seems that the table is really set for what this is doing in the first part of that sentence, where this agreement will be governed by the laws of the state of Florida. And that what follows that is understood in the context of that. Now, that's not to say that things couldn't be said after a sentence, a reference to being governed by the laws of the state of Florida, that would go beyond that. But it seems like here that the use of the term jurisdiction is just kind of describing Florida, the state of Florida. It is used in the sense that Florida is a jurisdiction, and that the governing of the laws of the state of Florida is something that's accepted by the parties. So what am I missing when I look at it that way?
Well, it's all about just one word, Your Honor. What does jurisdiction mean?
In context.
In context within this particular proviso. In doing so, the third DCA, just like we had suggested in our briefings to the third DCA, took a look at the definition of that word to assist that court in interpreting the provision. And in doing so, and looking at the Black's Law definition of the term jurisdiction.
Well, but I understand what you're saying, but that's only
Understood.
one definition of jurisdiction, and that's the jurisdiction that supports their conclusion. But there are other definitions of jurisdiction, namely that cut the other way.
Absolutely,
And I
Your
can
Honor.
look them up. I mean, I think you know those others are in the dictionary.
But I think within the context of what the third DCA had attempted to do at our insistence in terms of utilizing a definition was precisely to give context to the whole provision. And as Your Honor correctly points out, there's more than one definition. That's precisely why you need to kind of look at the whole context and see what the jurisdiction actually meant. I'm sorry, Your Honor, I can barely hear you. Yes, sir. Well, if I'm understanding correctly your question, if we're only referring to just the law itself, I lose. But if we're referring as to the venue, I stand on my two legs here, and I think that the third DCA does as well. Term jurisdiction here, when looked upon the qualifier, which is Florida, they want you to look at the qualifier as being laws, the term laws within the proviso. But it's really Florida. Florida is the jurisdiction that the parties agreed to. That's what the third DCA concluded in interpreting the term jurisdiction within this proviso. To give it sense, obviously you need to continue reading the whole 144 words contained within it so that you can determine that Florida is where the arbitration is to take place. The title is applicable law, but as Your Honor well knows, the title in itself is not dispositive in a question like this. In my humble opinion, Your Honor, and of course you can form a different opinion, you're free to do so. In my humble opinion, the term jurisdiction here, without reference obviously to the headings, if we were to reference every heading in every contract, then we would be lost with the substance of what the contract is really trying to do. But if we were to just look in isolation, the word jurisdiction in terms of the whole substantive part of the section, I can honestly conclude, Your Honor, that what we're talking about here is not only the location, but also the power of the courts within that location, which is what the third DCA concluded. One of the definitions, obviously, of jurisdiction is that power of the courts. That's what should not surprise you to be hailed into the court of Florida. Now, if I may continue with my argument, the so-called conflict that we have with the third DCA is non-existent. There's a recent case that we have cited in our papers that came out in July of last year by that same court, the fourth DCA, in which the fourth DCA treating Chapter 685 within the context of the provisions of that separate statute, which is more generally geared to contracts, it cannot. All those cases are in opposite. All those cases are in opposite, Your Honor. If you take a look at the particular statute that we're traveling under, all you need to prove in order to gain personal jurisdiction over a defendant is to comply with two things. One, that the proviso calls for the application of the laws of Florida. That's not an issue here. Two, that the agreement provides for arbitration in Florida. It's our position that the arbitration clause here calls for arbitration here in Florida. When you comply with those two things, much like in the back case that we have cited to in our papers, concludes that when you comply with the particular provisions of a statute, such as the ones in Chapter 685, which is what where it's all about, then personal jurisdiction is had on a dismissal posture. And so that's how you reconcile Hamilton, where, and you have to take a look at Back. In fact, Back cites to Burger King, which is the seminal case dealing with jurisdiction and compliance with jurisdiction in terms of due process, constitutional due process. And even in that scenario, Burger King recognizes that the parties to a contract can expressly or impliedly waive personal jurisdiction. Based on that, the Back case of the 4th DCA concluded you have personal jurisdiction as long as you meet the requirements of the statute. Once you have that requirement met, you need not go into minimum contacts or any of that analysis. Now, so that's why we're saying that this court should actually discharge its exercise of jurisdiction in this case. There is really no conflict between the cases that are cited by my esteemed opponent. And that the court affirm fully the 3rd District Court opinion in all its terms. However, if the court is inclined not to do so, then there are many questions that obviously were never dealt with at that very brief hearing prior to the evidentiary hearing where the parties were about to duke it out. And we would suggest that if the court is inclined to exercise its jurisdiction, re-examine the whole record de novo, that if it concludes that it would quash the 3rd DCA opinion, that it should send then the parties back for an evidentiary hearing to conduct a minimum context analysis, number one, and this argument that supposedly their own agent did not sign this agreement. There is simply no reason to believe on the record here that the agent, when looking at the 4 corners of our complaint, that the agent did not sign on behalf of its principal. And that's what we have argued below.
Let me make sure I understand. If we quash and remand, what else needs to be done at the trial court level?
Well, Your Honor, then we need to have our day in court. Then ANCLA's own due process will be truncated if we do not have an ability to prove up personal jurisdiction, number one.
I thought the trial court made a ruling that there was no personal jurisdiction and dismissed the case. Is that not right? The trial court did that, but what we're suggesting is that that was in error based on the conflicting affidavits that we had. And the 3rd DCA basically, by issuing its opinion, cured that error. It did cure the error. And so our position is that if you're inclined to send this back, then we should all have our day in court and be able to determine what needs to be determined according to your own de novo review. Unless you all have any other questions for me, I would reserve whatever time you might want to yield to me. I don't know if I'm over my time. I'm not really looking at the clock, and I apologize.
You've got 5 minutes left, but you don't have to take it.
Okay, very well.
But if you sit down now, you're done.
That's right, Your Honor. Then I'll sit down now. Thank you so much for your time. I appreciate, again, your welcoming to your prestigious court. Thank you.
Thank you, counsel.
Counsel, would you mind addressing the argument that there is actually no conflict with the cases?
Absolutely, Your Honor. We do have conflict because, as this court held last year in Cartsonis, you can have express and direct conflict where you have the application of a rule of law with substantially the same controlling facts that leads to different results. So what the 3rd DCA did here was say, hey, I'm going to convert this. This is going to be a form selection clause. There's no need to go any further. Whereas the 4th DCA in both Hamilton versus Hamilton and Ware versus Citrix says, okay, we have a form selection clause or a consent to jurisdiction clause, but we do need to go further and we need to see if there's due process because you cannot go beyond you can't just skip this process. In fact, it's written directly into the consent to jurisdiction statute that it cannot violate the U.S. Constitution. Correct. That's exactly right. Where the jurisdictional hook is based out of a contractual provision, you always need to have a due process analysis. Now, maybe it's not the traditional minimum context where you have a tort claim and it's just somebody have sufficient minimum contacts. It's a different analysis, of course, because we're in a commercial context. So you'd have to do an application of, are these the parties who agreed to this? Was there informed consent? Is this a freely negotiated clause? Because, okay, then you could argue purposeful availment to satisfy due process. Or is the enforcement unreasonable or unjust? Now, that might be...
I'm sorry to interrupt you, but so if we, though, decide this at the threshold that the court was wrong and that this is just a choice of law provision, does
Then
that
it's done.
does that affect our jurisdiction, though? I mean, because then we're not resolving I mean, at that point, then we're not doing anything on a conflict.
Well, you actually still are, because the second DCA in Burke Products said a choice of law provision by itself is insufficient to confer personal jurisdiction. So you'd still have a conflict on that ground.
Okay.
Because what the third DCA did here was basically say, well, here's a choice of law provision, we're converting this, and you have jurisdiction just based on this alone.
But the third DCA didn't rule on whether a choice of law provision, because they didn't think it was a choice of law provision.
True, but they're still saying you have a contractual provision. So that alone is grounds for a conflict, because we've got now Burke Products out of the second DCA, Hamilton and Ware out of the fourth DCA saying a contractual provision by itself is insufficient. In fact, that's what the Florida statute says. And whether this is the arbitration statute, as my esteemed colleague is arguing, or a consent to jurisdiction clause under section 685.105 is a distinction without difference. The point is, do you have a contractual provision that by itself can confer personal jurisdiction without due process? And the answer is no. The law is clear on that.
It's an odd jurisdictional thing, right? Because you're arguing that there's a conflict, but the conflict exists because of the erroneous interpretation of the contract by the third. And once you remove that, you're arguing, then you've resolved the conflict that wouldn't exist anymore in the law by a correct interpretation of the contract.
That's true. The third DCA, in interpreting it this way, created the conflict.
Let me ask you about the argument that if we were to quash the opinion, that there's still something left to be done at the trial court level. Do you agree with that?
No, if you quash the opinion, then the trial court's order is, there's no choice of law clause. I mean, this is a choice of law clause and that's it. And it was undisputed that there was no minimum context. The analysis is over because a choice of law clause cannot confer personal jurisdiction. It's done.
Was there the determination by the trial court that there was no personal jurisdiction? Is that still at issue?
I mean, they're arguing that it is, but we argue that it is not, because it was undisputed. Ankla's attorneys never disputed the lack of minimum context. Their argument below was always, we don't need minimum context because you signed a form selection clause. And the trial judge said, forum venue isn't even discussed here. This is just a choice of law clause. So if it's undisputed that there are no minimum contacts, I can't exercise personal jurisdiction.
So there was not a dispute about sufficient contacts to establish venue in a normal sort of way without the use of a statute.
Correct. There was none of that. It was undisputed. Now, they argued here that, well, there were affidavits. At no point during the hearing was there any reference to an affidavit. At nowhere in the trial court's order or in the subsequent order for rehearing does the trial judge refer at all to the affidavits. So there was no factual analysis being done by the trial judge here to determine minimum contacts, because they had already conceded that Tribeca didn't have minimum contacts. So the trial judge is saying, I've got a choice of law provision and no minimum contacts. I can't exercise personal jurisdiction here. This is clear. Unless this court has any further questions, I rest on my briefs. Thank you, Your Honors.
All right, we thank you both for your arguments in this case. The court will now be in recess for about 10 minutes.
All rise. Supreme Court of Florida is now in session. Please be seated.
The court now proceeds to the third case on today's docket, Shim versus Buchel. Forgive me if I mispronounced it.
Good morning, Your Honors. May it please the Court, John Bogdanoff for the petitioners. This is an appeal involving proceeding supplementary, but actually the issues are pretty interesting as they involve issues of sovereignty and separation of powers. The conflict issue between the 5th DCA decision in this case and the 4th DCA decision in Sargent relates to whether a Florida trial court has jurisdiction in proceeding supplementary pursuant to Section 5625 over assets or an asset located in a foreign country. The trial court, relying in part on the Sargent decision out of the 4th DCA, held that it lacked subject matter jurisdiction under 57.29 over the asset located in Korea. The 5th DCA disagreed, held that a Florida court has in personam jurisdiction and authority under 5629 to compel the petitioner, Shim, to turn over the foreign asset to the Florida court in the proceeding supplementary.
Counsel, I'm sorry to interrupt you. What is the asset at issue? Is it the check or is it funds on account at Woori Bank?
Well, according to the order of the trial court, it's essentially both. It's the check on representing funds on account in the South Korean bank.
Okay, so then my question about that is, if one of the assets is funds in a Korean financial institution, do you agree that something must be done to domesticate that judgment in Korea and seize those assets somehow? What, if anything, has been done to give effect to this judgment in the courts of that country?
To my knowledge, nothing. We believe the 5th DCA decision is erroneous on both counts, that the trial court had neither subject matter jurisdiction nor in personam jurisdiction which would extend to this asset located in South Korea. Under Florida decisional law, in personam jurisdiction over the petitioner Shim does not extend to adjudicating issues of the right to possession and title to an asset located in a foreign country. The decisions relied on by the 5th DCA holding that the trial court had in personam jurisdiction which would extend to requiring and compelling the petitioner to bring this asset from South Korea into the Florida court are inapplicable because they basically fall into two different camps.
Counsel, are you familiar with the decision of the Supreme Court in Fall?
Yes.
Okay. What do you say to where the Supreme Court in Fall said that a court's personal jurisdiction over a defendant gives the, and I quote here, power to require a defendant to do or to refrain from doing anything beyond the limits of its territorial jurisdiction which it might have required to be done or omitted within the limits of such territory?
Well, the way that decision has been applied in Florida has been two different contexts. One is where a real property situation where the court has authority to impose a certain remedy over property located in a foreign jurisdiction. This case, as well as the Hershert case, relied on Fall in saying that in that context where property is located in a foreign jurisdiction, the trial court having in personam jurisdiction can impose certain remedies relating to that property. For instance, a constructive trust was the Hershert case. The other case, Siunga, which also relied on that concept, was a case where the court said, well, a personal representative can issue a deed relating to property located in Romania. The court cannot directly affect title to that property.
But I'm struggling to see the material difference between that and what we have here.
Well, I think in this case, it's the seizure of an asset located in a foreign country and the requirement that that asset be brought from that foreign country into the Florida court. That's different than those cases that have applied the fall concept and language that you've referenced, which involve imposing certain remedies on property located in a foreign country, not requiring that anything to be brought back to this country, but imposing certain remedies that indirectly may affect the property. Here, we're talking about a direct effect. Direct title to this asset located in Korea is under the request by the respondents. They say we want ownership of that asset, and you need to, petitioner, you need to bring that asset back from South Korea into the Florida court, and we own it. Well, that's directly affecting the title, and the cases don't go that far. They don't say that you can directly affect the title. They say indirectly affect the title, and so we think this request here is far different.
But I understand it's an indirect effect on the property, but the court is acting on the person. And to the extent that the person has control of the property, it seems like to me that the action on the person would be viewed as having an indirect act within this framework on the property, and just like it would in these other cases you're talking about.
Well, but in this case, it's a direct effect on the title to the property, on the ownership of the property. According to what the respondents request, they sought an order to turn over the $4 million to the respondents. There's nothing, they want title to this property. So this seems to go far beyond the concept that you can indirectly affect property. This is a direct requirement that the property, under their theory, that the property can be brought from another sovereign nation into the courts of Florida.
But isn't the critical point that any remedy for noncompliance would just be directed to the individual, any punishment or whatever? It wouldn't, there's no one saying that the court could directly do anything to the property. So, I mean, that's what it isn't.
Of course,
that,
not sending the sheriff to South Korea, right? I mean, we all agree on that.
Well,
the sheriff probably wouldn't go anyway.
In this case, conceivably, it wasn't requested, but conceivably, there could be the possibility that the court is asked to maybe freeze an asset or enjoin that asset from being removed. But that wasn't the request. The request here was, we want that asset brought into the state of Florida. And so that's a direct action on that asset. That's not an indirect action, an indirect action may be freezing an asset or enjoining a certain effort to transfer that asset. Those would be more indirect. Those weren't requested here. Those aren't the issue in this case. This is, we want that asset and we want you to compel the petitioner to bring that asset back into Florida.
So if I hear you right, you're conceding that, who knows what date this check was drawn. Let's say the funds are no longer in the account. So the check is tendered to the state of Florida, but it's worthless because the funds have left the station. Our holding that being within our, sort of jurisdiction and our being able to exercise that jurisdiction, commanding the individual to tender the asset, that is the check, would not give us the same jurisdiction to seize and freeze assets. You're not arguing that, are you? We could then unscramble the egg and somehow compel Woori Bank to put the funds back in the account.
Well, I don't think there can, under the in personam jurisdiction theory, that any of that can be done, because that would require direct effect on the check, on the assets in the account, and that goes beyond the in personam jurisdiction, and now it's impacting the sovereignty of another nation. I would say that goes beyond what the settled law is. The other series of cases involve where there's a possessory interest. The GE case and the Shank case both involve situations where there was an asset in Florida. Shank was a stock certificates. General Electric was an aircraft, a jet. Both of those situations, there was a statutory lien or a statutory certificated interest in the asset. That asset was then taken out of the state of Florida The jet was removed, the stock certificates were removed to Canada, and the courts held that in those cases, that the Florida court did have the ability to affect those assets.
Well, those do seem somewhat distinguishable, don't they, in that a stock certificate is, or a bearer bond, for example, is an asset on its face, and an aircraft is a chattel, right? So I think reading chapter 56 together, levying on those things makes sense because they are, in and of themselves, an asset. Check's different. A check is nothing more than a promise to disburse to the order of someone certain funds. It doesn't create a lien, right? Like if I write 2 checks at the same time and they're both for the same amount and I only have enough to satisfy one, the first person who gets to the bank wins. The person with the other check doesn't have a lien, can't say, oh, hey, by the way, I also have this asset. So it would seem to me like those cases are distinguishable. Don't you agree?
Well, I do think those cases are distinguishable if for no other reason than they do involve possessory interests that already exist in the state of Florida on behalf of the litigants. And in that case, the state of Florida is vindicating the possessory interest that was created in the state of Florida, and the asset was then removed. And Florida is vindicating that statutory or lien interest that they have created. That's not our case. Our case is totally different.
Counsel, could I have you kind of switch just briefly and address the statute, 56.29 subsection 6, and why you think that does not give the trial court the right to enter this type of order?
Well, nothing in the statute talks about extraterritorial effect. The 4th District in the Sargent case refused to expand the statute beyond effect into a foreign asset.
But they admittedly said that was a policy decision. There was nothing that they could actually read in the statute about that.
Well, they were pointed to a New York case which involved a similar statute, and the New York court had read the statute expansively and said, well, there's nothing indicating that it doesn't preclude extraterritorial effect, so we're going to determine that as a judicial matter that the statute has such effect. Florida has a totally different approach. We've cited cases in our briefs that in Florida, a statute, in order to have extraterritorial effect, that's a legislative decision. And if the legislature determines that extraterritorial effect of a statute is warranted, they have to provide that in the statute. There has to be a clear intent from the legislature of extraterritorial effect. This statute, 5629, contains no such clear directive. It says nothing about extraterritorial effect. And so, as a result, the legislature has not given it that type of effect. So, if the legislature did want to have extraterritorial effect, Sargent was decided in 2014. They've had 6, 7, 8 years. The legislature could have gone back and said, well, the Sargent court refused to give it extraterritorial effect. We want 5629 to have extraterritorial effect. We need to amend it to provide that. They haven't done that. So
the statute, 5629 says the court may order any property of the judgment debtor not to be levied upon and applied toward the satisfaction of the judgment debt. The court may enter any orders, judgments, or writs required to carry out the purpose of this section. And that's pretty specific.
Well,
once I have you, jurisdiction over you, and then I order you to obtain and bring this, make these things available.
The case law we cited indicates that just using the word any is not enough to provide extraterritorial effect. If the legislature intended it, they needed to be specific. Using words like any doesn't satisfy the requirement. There has to be a specific provision saying that this statute have extraterritorial effect.
Where is that in our law, in Florida's law? Is there any statutory provision you can direct us to that creates a blanket presumption against extraterritoriality unless specifically invoked by the legislature?
Not that I'm aware of. I do know that there's ample decisional law. The Equitable Life case that goes back to 1911, as well as other cases that we cited in our brief, stand for that proposition that if statute is going to have extraterritorial effect, it's for the legislature to make that determination. And like I said, in this case, the legislature has had every opportunity to make that determination. They have not done so. So we think the Sargent case was correct in refusing to read the statute broadly like the New York court did, rejecting that concept, and not judicially expanding the statute to provide for extraterritorial effect, and to leave that issue up to the legislature, as Florida law suggests.
Counsel, you are now into your rebuttal time. You may keep going, but you are consuming your time.
I'll save my last 4 minutes and 40 seconds. Thank you very much.
May it please the court, Edmund Kester for the respondents. I'd like to begin with section 56.29, and there is under subsection 6 a part where it says the court may enter any orders, judgments, or writs required to carry out the purpose of this section, including those orders necessary or proper to subject property or property rights of any judgment debtor to execution. I submit to the court that 56.29 subpart 6 and the whole section is not only broad, but is also specific. It actually says the court can enter orders requiring property to be subject to execution. What brings us here today is basically a bearer instrument. The testimony is it's a cashier's check, a negotiable instrument in a safe in somebody's home in South Korea. The court has undisputed personal jurisdiction over the debtor. We ask the court to require the debtor to bring the bearer instrument, the negotiable instrument, to the state of Florida so it can be executed on. There is no effort whatsoever to have the court send a sheriff over, some kind of in rem jurisdiction, to go take the property. It's simple. The debtor brings the check over to Florida, and then we execute on the check.
Okay. Does it require any endorsements?
The court, it may require endorsements. We don't have a copy of the instrument. So if they bring the instrument over, they show it to the court in the proceedings supplementary. If it requires endorsement and it's not truly a bearer instrument, it's not truly a cashier's check made payable to anybody, the court, like it can require somebody to sign a deed, it could require him to endorse the check.
Okay. And the same question I asked your colleagues. What if the funds represented by the instrument, you're characterizing it as a bearer instrument, are no longer on account at Woori Bank? Play that out for me.
Garden variety contempt issues. Courts all the time, when they want to put somebody in civil contempt, especially if it's not to pay a debt, do they have the ability to pay? If they do have the ability to pay and they say you have to pay, in this case, do you have the bearer instrument, the cashier's check? He says yes. They say send it over here. If he then goes to the bank, closes the account, moves the money to Japan or Hawaii or somewhere else, the court has contempt powers again and can say, we entered a final judgment against you, we had a proceeding supplementary, we had you testify, we had your deposition testimony, we know you had the money, you admitted you had the money, and now you moved it again to circumvent the court. The court at that point could consider contempt, which is specifically permitted under 56.29, and could consider incarceration, with the purge condition being actually give us the money this time. Yeah. Nobody is saying to go over to a bank in South Korea, judge, and somehow attach it.
So again, I'll ask the same question I asked your colleagues. What steps, if any, have been taken to do what you would do in a garden variety judgment enforcement case abroad and domesticate the judgment in the country where the asset is and attempt to enforce there? Has anything been done in this case to do that?
We have very good counsel over there. There's litigation over there where they're trying to relitigate all these same issues in South Korea. The next hearing is set for March 24th. We won at the trial court level. I went over to South Korea myself. It's up on appeal now, and March 24th, we believe, will be the final hearing. We also are seeking domestication over there as well. It does raise the point, though, that the idea of proceeding supplementary in personam jurisdiction is to hold the debtor accountable. Otherwise, you could just bounce the money around the states, bounce the money around the world, bounce the money around the country. If you found a country that didn't allow domestication of judgments, you could just put the money over there, even if you were a plaintiff in Florida, even if you lost in Florida, even if there was a judgment against you, you could just jump it around. So in the Sargent case, where there's discussion regarding this could affect the need to domesticate judgments, it sort of misses the point. You may domesticate a judgment if you need to. You may no longer have personal jurisdiction over the defendant because he may be gone and you can't get him back in court or something like that. There could be real property. You want to domesticate a judgment, get yourself in line in the lien. You want to foreclose that property in another jurisdiction. The domestication process doesn't go away. It's clear from the case law there is a very big difference between in rem and in personam. And we're here only on the in personam. We are not here in any kind of prejudgment writ of attachment. We're not here in some territorial case where the state of Florida is trying to seize fish that were caught outside its territorial boundaries. We're not here in any of those contexts. And I would suggest, too, that the GE case cited by the 4th District Court of Appeal as being different because there was a fuel lien. When you look at that case, the court was actually very clear. They were only going under in personam jurisdiction. The lien hadn't really been perfected. There wasn't anything tying the jet to Florida. They said GE has the minimum contacts. We have personal jurisdiction over GE. Bring the plane back so these people can try and execute on it and enforce their lien. The court didn't say, we have a lien, send the attorney general or send the sheriff of Dade County and have them go find that plane and bring it back. They said to Boeing, they said to GE, bring the plane back.
Are there any kind of restrictions? Like what if he had taken the money and bought a fleet of vehicles? Is he required then to put 20 automobiles on a ship and have it shipped from South Korea?
Super interesting. I thought of that last night because apparently he has a nice Porsche over there. There is some discretion from the trial court as to what the trial court does. So if you say the fleet of trucks or something like that, if we were to come in and say, Your Honor, we want you to force this debtor to bring this fleet of trucks over, and the debtor said, hey, wait a minute, there's liens in that other jurisdiction, I don't own them all, the transportation costs would outweigh the value of the trucks, this would be overly prohibitive, I can't do it. That's the garden variety trial court evaluating what we're doing. And he has other assets over there. We went for the negotiable instrument that he said was a cashier's check in his safe because it was particularly insulting to the creditor and the court to say, I have the money and I'm not going to give it to you. If we literally looked at his Porsche and said, okay, how much does he owe on it? What's it really worth? Are we really going to try to ship it? Are there any dealership laws or car laws that we're going to have to deal with trying to bring in a foreign car into America? And the court has discretion and the parties have discretion. It would be an asset by asset analysis, both by the creditor and by the court, and it would be up to also what the debtor has to say. And there also has to be an ability to comply. So if you're going to require somebody to do something using in personam jurisdiction and they're not able to comply, they would do that. In the GE case, if
so
they were
your position is any personal property is game, subject to whatever discretion the trial judge has on whether it makes sense or not.
Well, and whether the debtor would have the ability to comply. And the example I was just about to give is, let's say GE said, the plane's broken, it's been shut down by the FAA, we don't have our quarterly services, we have no way to get it to Miami, we can't bring it to you. If they were then to hold GE in contempt, and it were up here on this court as to whether you could hold somebody in contempt that doesn't have the ability to purge, I think the clear ruling would be there had to be a factual finding that they could comply. But yes, proceeding supplementary would let you get at any personal property anywhere in the world if the debtor had the ability to comply, it made sense, and it could be done.
And because you're proceeding totally on this in personam theory, this whole issue about the extraterritorial application of the statute is just a total distraction because you're statute to the person, not extending its reach abroad.
Correct. And we would be back to contempt issues. So if they canceled the bank account at the bank, So when the bearer instrument was presented, it didn't clear because the bank account didn't exist anymore, assuming the bank let them do it. And they moved the money around. We'd be back at another evidentiary hearing saying, Judge, here's the dishonored cashier's check. It came back as account closed. We wouldn't say, Your Honor, let's go after the South Korean bank. It would be, bring the debtor back in, let's get him under oath. What did he do with the money this time? And then where is it now, and can we prove what he did with it? And that would be exactly how the case would proceed. And it wouldn't be unduly burdensome at all on the judiciary. We see this happen in all of the other cases. Ex-husband takes the stock and puts it over in Canada, and they have to cancel the stock and have it reissued to get it back. It doesn't have anything to do with whether you have a security interest in stock or anything like that. The stock was removed. They didn't send a sheriff over to Canada to bring it back. They made the debtor do it. Same thing on all these other cases. You know, that's the way it is. In the Second District Court of Appeal, in the Dusaya case, a Texas court said that a wife had to sign over a deed to Naples property in Naples, Florida. Refused to do it. Court had the right to enforce it. They said, by the way, we're going to ignore the in rem portion of the Texas divorce judgment that said he now owns it. And we're going to ignore that. We're not going to give it full faith and credit, but we're going to enforce and give full faith credit to the in personam part of the judgment, which is she has to execute the deed. The Sewinga case, telling the personal representative he's got a deed property over in Romania, the First District Court of Appeal said, we're not saying what proper title is over in Romania. We're not going over there and messing with their affairs. We're saying we're a probate court. We have jurisdiction over a personal representative, and they have to do it. The Fifth District Court of Appeal in Hershey, when the California court said I'm imposing constructive trust on property in Florida, the court enforced it, again, in personam. It said remand for everybody to address the homestead issues. Is there a homestead protection if you've taken money out of a trust and bought a Florida homestead with it? The appellate court said, I'm not dealing with that. It's ripe now. Go back and take a look at it, trial court. But that's what all of these cases say. The Sargent case is an outlier. And if the Sargent case were allowed to be good law, and if the argument by my esteemed counsel were that courts have to have territorial, they've got to find something in a statute that discusses territorial, imagine coming back here on anything else, on a discovery matter. Somebody says, well, I've taken all the documents and hard drives and I put them in Alabama. So, Your Honor, I don't have to produce them in my discovery in Florida because there's nothing in 1.350 that says it's extraterritorial. And the court would say, what are you talking about? You're the plaintiff in a case. It's relevant discovery. I've told you to give it to you, and I'm going to hold you in contempt if you don't. It's, no. It's extraterritorial. I had it moved to Alabama. And by the way, if you get some kind of order and you domesticate it in Alabama, I'm moving it to Georgia next time, and we're going to play the 50-state game. It would have broad implications to suggest that a court would not have the ability to exercise in personam jurisdiction, require people to respect the court, and follow the court's orders. I could continue to talk if any of the justices have more questions, I'm happy to answer. Otherwise, nothing further. Thank you.
Just briefly, in the Burns versus Rosen case, that was a first DCA case, the court did address using terms such as any and all in a statute as to whether that's sufficient to provide for extraterritorial application, and they rejected that concept. They said extraterritorial effect is not to be given by implication.
How do you respond to counsel's argument that all of that is sort of a red herring because they're not proceeding in rem? They're not trying to get the funds, on deposit. They're trying to command this individual to comply or face contempt. How do you answer that?
Well, they are seeking the funds. They want them brought into the state of Florida. So they're not
Perhaps, but not in this action. Your opponent has said that they are proceeding in this action solely in personam, and that the remedy they are seeking is a command for an individual to behave a certain way. They are not, in this action at least, seeking any kind of in rem relief. Doesn't that moot the whole discussion about extraterritorial effect? And if not, why not?
No, it doesn't, because first of all, this was an action under 5625. So in order to give extraterritorial effect, the statute has to provide that. As for the in rem issue, the in personam issue, We pointed out the cases are distinguishable that the opposing counsel relies on, as well as the Fifth DCA relies on. In this case, there was no asset that was in Florida that that the petitioner removed to another state. This is a situation where this asset is in Korea. He hasn't taken an asset like the jet that, for unpaid fuel bills, had a lien slapped on it and then was removed from the state of Florida after that happened. Or the case with the ex-husband who took the stock certificates that had been issued in Florida, took them and brought them to Canada, and then the Florida court says, "Nuh-uh-uh, that's not going to cut it." Notice in that that's the Shank case. The court didn't say bring the stock certificates back even. What the court said is, you need to reissue new stock certificates and give it to the opposing side. So even in that case, the court didn't say bring those stock certificates back. This case does not involve taking assets. It doesn't involve taking discovery material and moving it out of the state. This is an asset that's been in Korea. There's no indication whatsoever that this asset was here in Florida and then has been removed.
It seems like that distinction would only matter in in-rem cases, not when we have a personal jurisdiction type case.
Well, the personal jurisdiction still has to be consistent with due process. And if this asset was never in Florida, there's no connection. If we're going to talk about due process and in rem, there's no connection with this asset to the state of Florida. So to say that the state of Florida, the court,
but why does that matter?
Because in personam jurisdiction is the concept is basically has to comport with due process, and any
over the person, not the property, though, right?
Well, but in this case, it's the person whose asset is a Korean asset, just as if these were stock certificates in Korea that had, in a Korean corporation that had never been in the United States, have never been, in the state of Florida.
So, counsel, I want to make sure I'm clarifying what you're saying. Let's say judgment was entered for $100,000 against someone, and their money was all in an Alabama bank. That's right next door. Is it your position that under oath they said, yes, I have $100,000 in an Alabama bank, or let's say it's a cashier's check in Alabama, and would the court in that case, or is it your position they would not be able to say, you need to bring that to Florida and pay?
Under in personam, if
yes,
they had in personam
they have
jurisdiction?
that jurisdiction.
I would say no. I would say the remedy is, as opposing counsel indicated, they're seeking to domesticate and obtain this asset by going to Korea, and apparently they've got some action in the works, and that's what they're attempting to do.
But that's not exclusive of also seeking in personam relief, is it? Like, those two things can't be mutually exclusive, or else you're in the box that he's talking about with the discovery materials. Any chattel that you'd move at any point, would you just sort of play whack-a-mole? That can't be the law.
Right, but there's no indication, in this case, that there's any movement of this asset. And furthermore, as I said before, this asset was never in the state of Florida. So we're talking about an asset that is a uniquely South Korean asset, and trying to use in personam jurisdiction to reach that asset, we think creates real issues of sovereignty, and that's.
So if it had been here and he moved it to South Korea, then it would be okay to get it?
I think that might be a different case. I think that in that case, an argument might be able to be made that there's at least there was some action in the state of Florida. Even so, the cases that we've cited and discussed don't go that far and say that you can go into the foreign country and require the defendant to take that asset and bring it back. They don't seem to go that far. So, thank you very much. Appreciate your time and interest.
We thank you both for your arguments in this case. The final case on today's docket will be conducted remotely at 11:30. So the court will now stand in recess until we reconvene remotely at 11:30.
All right.
Test 1 2 3 4 5.
Order in the court. Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning and welcome to this remote session of the Florida Supreme Court. The case that we consider now is in re amendments to Florida Rule of Criminal Procedure 3.851 and Florida Rule of Appellate Procedure 9.142. I'd like to first recognize Judge Sisko.
Thank you very much, Chief Justice Kennedy. Can you hear me?
Indeed.
Okay, thank you. May it please the court, I am Judge Michelle Sisko, and I'm appearing on behalf of the Criminal Procedure Rules Committee of the Florida Bar. I'd like to thank you for allowing me to appear remotely. If I could, I would like to begin with my committee's comment regarding the deletion of the automatic appeal requirement currently contained in Rules 3.851 and 9.142, and that would be automatic appeals of the trial court's granting of either a motion to dismiss a post-conviction motion or a motion to discharge counsel in a post-conviction proceedings. Our committee unanimously voted to retain this important guardrail. Death is different is a common refrain in the trial courts when dealing with these cases. And our committee feels that maintaining this important safeguard is in keeping with this sentiment. And again, this was a unanimous opinion amongst all of the members of this committee. Moving next to the removal of the requirement in Rule 3.851, the capital defendants must be represented in all post-conviction proceedings. In discussing this issue as a committee, we reviewed the court's 2013 opinion in Lambrix versus State, Lambrix, as well as this court's opinion in 2014, which actually implemented the change to require representation of counsel for capital defendants in a post-conviction proceeding. As you all are aware, Lambrix was a capital case authored by this court in 2013 before the rule change occurred. In that case, the trial court summarily denied the defendant's fourth and fifth successive post-conviction motions and denied the defendant's motion to discharge his appointed counsel. In that opinion, this court acknowledged a capital defendant's right to self-representation, but stated at page 900 of that opinion, quote, any right of self-determination and self-representation during post-conviction proceedings, however, does not outweigh this court's solemn duty to ensure that the death penalty is imposed in a fair, consistent, and reliable manner, and to guarantee this court's administrative responsibility to minimize delays in the post-conviction process. In denying the defendant's writ of prohibition for the trial court's denial of defendant's motion to discharge counsel, this court cited to the United States Supreme Court opinion in Martinez versus California. In Martinez versus California, the United States Supreme Court held that in the federal system, there is no Sixth Amendment right for defendants to be permitted to represent themselves in the appellate process, as the Sixth Amendment guarantees only apply to individuals who had not yet been convicted, and that the status of defendants in a post-conviction posture were constitutionally distinct from those pending trial. The United States Supreme Court did, however, create an exception for state court post-conviction procedures as dictated by the respective state court constitutions. Secondly, in that opinion in Lambrix, this court additionally noted that the defendant had already requested counsel to be appointed when the death warrant was issued. The court noted that permitting the defendant to discharge counsel at that stage, at the current stage in the post-conviction proceedings, but then reappointing counsel when the death warrant was issued would, quote, only create delays when the death warrant was issued, close quote. After considering all of these aforementioned cases, our committee, by a vote of 30-5, voted that the requirement for the appointment of counsel for capital defendants in post-conviction proceedings should remain. The majority of our committee expressed the same concerns as expressed by almost all of the other stakeholders that submitted comments in this case. For example, inevitable delays of this court's stated goal of resolution of all post-conviction proceedings for capital defendants within 2 years of the filing of the initial post-conviction motion. The logistical issues of an inmate on death row conducting discovery, and particularly discovery depositions. The lack of the defendant's ability to obtain records, not only from the repository, but any other outside sources. Particularly, there's been a number of technological advancements since Lambrooks was decided in 2013, and that is a lot of discovery exchanges now occur in an electronic format. That would be particularly difficult for inmates on death row. Even the most basic issue of the ability of capital defendants to file motions electronically through the portal would represent challenges. We discussed as a committee that these issues are particularly acute in death warrant proceedings due to the compressed timeline, particularly if an evidentiary hearing is required. As you all are well aware, the governor will include an execution date on the face of the death warrant. This then sets in motion an extremely expedited process for the courts to resolve all post-conviction matters. By way of example, I've handled 2 of these death warrant proceedings before, the most recent one being in 2019, that of Bobby Joe Long. In that case, the governor signed the death warrant on April 29th of 2019. The execution was scheduled for May the 23rd of 2019. As the presiding trial court judge, I was given until May 6th of 2019 to conclude all pending matters at the trial court level and to issue a written order. In Mr. Long's case, this included an evidentiary hearing with expert witnesses regarding Mr. Long's individual medical condition and whether the 3-drug protocol for execution would implicate the 8th Amendment prohibition against cruel and unusual punishment. This was a total of 8 days for the trial court judge, meaning me, to complete an evidentiary hearing with expert witness testimony and author a written order. I was only able to meet this deadline with the accompanying professionalism and tireless work of counsel for the Attorney General's office, defense counsel, and counsel with the Department of Corrections. In all candor, I do not think that this would have been empirically possible with a pro se capital defendant. With all of that being said, I would like to acknowledge the minority position on our committee. I think this sentiment is one really of philosophy and is best represented by Justice Scalia's dissent in Martinez, where he stated, quote, "Our system of laws generally presumes that the criminal defendant, after being fully informed, knows his own best interest and does not need them dictated by the state. Any other approach is unworthy of a free people. As Justice Frankfurter put it for the court in Adams versus United States, to require the acceptance of counsel is to imprison a man in his privileges and call it the Constitution." Thank you very much, Justices. It's been an honor and a privilege appearing in front of you today.
Before you move, I've got a question.
Yeah.
And I understand the concerns, and let me say before I get to my question, we appreciate your comments, your committee's comments, and all the other comments that the court's received. This is a thorny issue, and obviously there's some deep philosophical differences swirling around here, and we appreciate the various opinions and the various points that have been made. But let me ask you about one thing. We started on this journey, I think, with Davis, and that raised some issues about the scope of a defendant's waiver of claims. Do you have any thoughts about how we should address that? I mean, one view is that there's a if you're gonna waive proceedings, that's once and for all and forever. That's not the position the court took. We thought that that was not what we wanted. The majority did not want that. There's also the thought that, well, you could only, maybe you should only be able to waive the claims that are actually currently pending. Another thought is if you do it expressly, you could waive those claims and any other claims if you do that expressly, but that you would not, just because you waive the claims that are now pending, that would not be construed as a waiver of all future claims. Do you have any thoughts about how that should be structured?
Well, and thank you, Justice Kennedy. And again, my committee did not discuss this particular issue, so I'm giving you just my personal opinion. And so I just want to make clear that we didn't discuss it, and I don't want to be speaking on behalf of the committee. Based upon my own personal opinion, I do think that a defendant should be permitted to waive any and all claims. And I don't necessarily think that it has to be just pending claims. There would be two caveats to that, however, in my opinion. One would be for newly discovered evidence. If it truly constituted newly discovered evidence, I think that would be one exception. The second exception
So you're saying even if they said, I'm done with this process, I don't want any more of this, finished, and it's very clear that they intend to waive future claims of undiscovered evidence, of newly discovered evidence, you'd say that they still shouldn't be able to do it. I just want to be clear about that.
Well, it causes me some heartburn because you don't know what you don't know. Right. And what if suddenly, as a capital defendant, you've waived all of your post-conviction rights, and then you get a letter from the FBI that says, oh my gosh, the DNA testimony that was provided to convict you was actually faulty, and it can't be relied upon any further. And I do think at that point, then it would be a grave injustice to prohibit a defendant from raising that issue. So that's why I would one exception would be newly discovered evidence for me personally. The second one would be in death warrant proceedings, because there's two issues. Stepping back with death warrants, they don't always require an evidentiary hearing. The first one I did not require an evidentiary hearing. I ruled, it was really matters of law, and I ruled on them. There were challenges to the 3-drug protocol for executions, but that issue had already been settled by the Florida Supreme Court, and there was not reason for an evidentiary hearing, in my opinion. In Mr. Long's case, he had a specific medical condition, and because of that medical condition, his argument was that the execution protocol would inflict cruel and unusual punishment on him. The second exception that I can think of for death warrant proceedings is if there is a change in the 3-drug protocol for executions. I think historically what you all have seen is that there will absolutely be a challenge. The first defendant post a change in the execution protocol, drug protocol, that there will be a constitutional challenge to that protocol for the first defendant under a death warrant, and an evidentiary hearing will be called for. So I do think, again, with defendants, their medical condition may change over the years they're incarcerated. The 3-drug protocol may have an impact on them that hasn't been contemplated. So those would be three exceptions, I would say. Well, two. One for death warrants. I do think that death warrants should be excluded, and I do think for newly discovered evidence. Other than that, I do think defendants have the absolute right, as all defendants do, capital defendants as regular defendants, to make the knowing, voluntary, and intelligent waiver of all post-conviction claims.
Right. Thank you. Justice Poston, I think you had some questions.
Just let me quickly ask, what's your and the committee's view on the utilization of standby counsel and when there's a death warrant going on?
Well, again, we didn't discuss that issue specifically because the vast majority voted to retain counsel, so that the defendant should still be required to have post-conviction counsel. So again, I cannot speak to that as far as what the committee feels. I could only speak to my individual opinion on that.
Well, you've got a lot of experience. What is your view on that?
Okay, so in full disclosure, I voted with the minority. So I was one of the 5 that felt that defendants should have the right to self-represent in post-conviction proceedings if they choose. That doesn't undercut all of the arguments I just made. I believe every word I just said regarding how incredibly challenging it would be. It would be incredibly challenging. But I do think that if a defendant, if I'm the last judge that defendant may ever see before they are executed, and that defendant truly wants to represent themselves, I would be inclined to let that defendant do so. And it really just comes down to a philosophical issue. With regards to the appointment of standby counsel, that would have to be automatic. But I do think some of the comments, I think particularly by the Criminal Court Steering Committee, you know, they did make some really, really valid arguments regarding how standby counsel is not necessarily a great substitute. But my own personal opinion is that if the court were to change the rules, that would have to be automatic. It'd have to be, because for all of the reasons that I just discussed, all of the logistical issues, particularly with any evidentiary hearing.
So you started off with a pretty compelling account of, you know, your death warrant experience and the tight time frame, and you concluded your story there by saying that you wouldn't have been able to do it without counsel. And, you know, obviously you were just sort of the first step in a process that was going to, you know, have steps other. So if there had been delays, I mean, could you just sort of play out for us? I mean, are you suggesting that, you know, unless the governor then sort of readjusts his time frame to account for the self-representation, I mean, are we essentially kind of introducing, you know, inevitable delays into these things, or what?
In my opinion, again, I'm not speaking on behalf of the committee, but in my opinion, yes. I think then the governor would have to be cognizant of the fact that a self-represented defendant who is on death row is going to face challenges in litigating their post-conviction proceedings that a represented defendant would not. I stand by what I said. If Bobby Joe Long were today, if that same case, and I was only given 8 days, I do not believe I could complete it in 8 days. I do not. Effectively and fairly.
Thank you.
All right. Well, we thank you very much, Judge. Now
Thank you.
Go to the next to Ms. Kiefer.
Good morning. May it please the court, Suzanne Keffer on behalf of Capital Collateral.
I'm sorry, I mispronounced your name. I apologize.
No problem. On behalf of Capital Collateral Regional Counsel South. So the comments that we submitted to the court focused primarily on the issue of self-representation. And we urged the court to contemplate whether or not a capital defendant should be allowed to represent him or herself based on several considerations: practical considerations, administrative considerations, equitable and constitutional considerations. Remarkably, and I say this having been in the capital post-conviction arena for some time, all of the agencies and committees that submitted comments agreed that a capital post-conviction defendant should not be permitted to represent himself. And they agreed across the board on those reasons that I just mentioned. Like I said, that's an agreement that we don't often see in capital litigation, for sure. I wanted to talk a little bit, and Judge Sisko did mention some of the practical considerations, but as an attorney representing capital post-conviction defendants, the practical considerations really are substantial. And I think at the heart of those considerations is access to witnesses, access to records, legal materials, access to experts, access to opposing counsel, and most significantly, access to the court itself. There simply is too many moving parts in capital post-conviction for a convicted defendant to be able to navigate from death row. one of the most significant areas, and it is a large part of capital post-conviction litigation, is public records. The public records litigation that we partake in is unique to this area of the law. Rule 3.852 applies only to capital post-conviction. What that means is that this is beyond the discovery that a defendant would receive pre-trial. This is volumes and volumes and volumes of records.
Counsel,
and they come in the form.
These are obviously very significant real world considerations that the court is very mindful of, and that I think the commenters are, as you say, unanimous about. I wonder if you could respond, however, to what Judge Sisko was saying about the role of waiver in this entire consideration. What role, what importance do you ascribe to waiver, for the defendant who doesn't want the volumes of evidence, who doesn't want to make the kind of deep dive that you're suggesting is very difficult to make? How does that figure into your analysis?
So it depends on if you're talking about waiver of the post-conviction proceedings, or you're saying waiver of and dismissal of counsel to represent yourself. One, waiver of proceedings, we're all familiar with Davis, and I think that certainly I would echo their right to waive the proceedings as long as the procedures are in place to make sure that that was reliable, and that involves the automatic appeal to this court of what occurred in the trial court. I do agree with Judge Sisko, though, that there are issues that arise that the defendant may not know. As she said, the defendant doesn't know what he doesn't know. There can be changes in law of constitutional magnitude. We saw that with Hearst. There can be, as she said, newly discovered evidence. There have been times where we, without reaching out for the information, have received letters that may suggest Brady or newly discovered evidence. And certainly there are issues that arise during a death warrant, litigation of method of execution. While it remains that it's lethal injection, the drug protocol has changed many, many, many times.
I think I'm willing to stipulate that going without counsel in a death proceeding is a bad idea. Like, let's just assume that everyone agrees that it's a terrible idea, and there's nothing to recommend it. I guess the question is, what do you do with the sort of the core fact that it is still within the realm of someone's choice to, fire a lawyer, not want to proceed? How do we thread that needle? What is the rule you'd have us have?
Honestly, I think the way the rule is written now, where and taking into conjunction Davis, that other issues may arise that he would need counsel for. I think it's worked in that there are procedural safeguards in place so that when a defendant makes that choice, his competency is reviewed, and then a colloquy is conducted of the defendant, provided he's competent, he's been found competent. And then there is the safeguard that the defense attorney that has been fired files the automatic appeal. And that's the safeguard that needs to be in place to ensure that the trial court and the prosecutor and the defense attorney have gone through the process in place to determine that the defendant, like I said, is competent and that this is knowing, intelligent, and voluntary. So I think that in terms of the automatic appeal, that is something that needs to remain in place. I want to go back a little bit because you mentioned what do we do with a defendant that doesn't want to avail himself of all that the post-conviction process allows, from filing 3851s, the public records process, whatever it may be, interviewing witnesses, hiring experts, whatever it may be. If the assumption is that they're going to represent themselves, but not avail themselves of what the post-conviction process provides, then we're talking about review that is not meaningful and effective. And I think that's where.
But counsel, I mean, how do you respond to the point that if they are fully informed and an explanation is made about the difficulties that will be attendant with self-representation, just like we have in the Feretta context. I mean, obviously, it's not easy to represent yourself in a capital murder trial either. I mean, there are all kind of issues and difficulties with a defendant who does that, but they're told, and if they decide to do it, then the difficulties are difficulties that they have chosen to assume. How do you respond to that?
Because I think that the post-conviction process and the rule that they be represented by counsel speaks to how the death penalty is administered in the state of Florida and how it must be administered in the state of Florida to meet the demands of Furman. And all of these things have been put in place in order to meet what the United States Supreme Court required. And so when you do away with that and you say, well, they've made this knowing waiver, they're not going to have public records, they know they're not going to because it's difficult, you're taking away a piece of that component. And I started to say that the problem with that is it's not just a disruption of the criminal justice system, it's really a disruption of constitutional magnitude.
But counsel, I'm sorry to interrupt you. It seems to me, though, that your stronger argument is the disruption to the system, because it seems like there's and maybe I'm not sure if I'm understanding the question right, or even my understanding of this proposal is that if the court allows self-representation, that the system is going to essentially have to try to accommodate that by giving the person access to a law library, giving them records, giving them a way to meet with people, et cetera, et cetera. It hasn't been my understanding that we're going to proceed in a way that says to this person, yes, you can represent yourself, but if it's not convenient for us to allow you to do all these things, then you're out of luck. That's sort of a consequence of your decision. So to me, I understand in some way the philosophical thing about personal choice, but the person has put themselves in a position by having been convicted of a capital crime and have it be affirmed on appeal, et cetera, that they're essentially making a choice that's having all these collateral consequences for a lot of other people, including the victims' families who are going to be subjected potentially to these delays and yada, yada. And my understanding of this rule proposal is that that's sort of baked into a proposal to let someone represent themselves. I mean, is it your understanding that if someone chooses to represent themselves, that they aren't going to be, people aren't going to have to try to accommodate the records and the witnesses, et cetera, et cetera?
I think that the problem is, how do those accommodations happen? How do they happen in the face
right? But the point is, the system is going to. But let me just ask you though, forgetting the logistics of how, isn't it your assumption that they will have to try to be made? I mean, putting aside like how it's. I mean, obviously we can't anticipate all the different things. Is the proposal, as you understand it, as all the commenters understand it, that essentially if the burden, the burden is on the self-represented, petitioner or litigant, whatever you want to call him, or are we going to have to try to essentially facilitate his self-representation by doing whatever it takes logistically to give him access to the things he would need to be able to do?
I would think certainly if this is the route that the court goes to allow somebody to represent themselves, then all of these different agencies and the court and the state attorneys, they are going to have to accommodate that defendant. But what our comments point out is that's beyond difficult in this circumstance. We, and I won't belabor it, but we laid out in our comments the case of Salazar. And the court allowed Mr. Salazar to represent himself. I don't believe they got much further than additional litigation over the litigation that already is inherent in public records. They had to appoint a special magistrate to go through the records and decide which ones comply with DOC's administrative code, what he could receive. I mean, there's just certain security concerns that I don't know that they could do away with them and allow a self-represented capital post-conviction defendant to be able to adequately represent himself. And so we spelled out some of those problems in our comments, and ultimately, Mr. Salazar was appointed counsel again, because it simply it was not working, and the state had to point out Gordon and what Gordon says and the fact that it wasn't working. So while they seem like, you know, impracticalities that maybe can be accommodated in reality for the stakeholders in this process, we know it's not going to happen. And then that's when it's not just delay, it's not just disruption of the streamlining of this process, it becomes concerns of constitutional magnitude. It affects the fairness, reliability, and consistency of this process.
Let me explore with you and try to articulate and get your reaction to my concern about the rule as it exists. And let me start with my assumption. The way it works is that a capital convicted defendant has only two options. They can waive everything and therefore not be heard in the state court of last resort in the case in which the sentence of death is imposed, or they can keep counsel but not really have a say in what counsel does. They may want to say to us, this is my life at stake, and this is the claim I want to make. And you may say that, well, that's not a claim that I can make, and so, but we're going to make all these others. I don't want you to make those others. Well, then you can waive everything, including the claim that you want to make. And so there are constitutional implications of that. It's a person that has a right of self-representation, and we're telling him that we don't care about your constitutional rights because it's just too hard. And that's troubling to me. What am I missing in that explanation of how it works and the choice that defendant is making?
I agree. I think that it is a troubling choice for a defendant to make, to give up all of his claims and not have counsel, or stay with counsel and, as you said,
and
maybe
lose
his
complete
claims
control
aren't
of
heard.
his defense in a case in which the state has imposed this penalty. You can't talk to the court. I mean, it seems like almost.
Well, really, you're losing control of offense, right, counsel, not defense. This is offense.
Sure, and I understand that, but counsel has a role for a reason. And I think Lambrix really addresses your question in this regard, because Lambrix filed claims and petitions and just over and over and over again. And the court constantly found that the claims were meritless, frivolous, and dismissed them. And required.
Let me ask you this:
remain.
what if we had a procedure that allowed for the appointment of counsel, required it because of all the more indirect constitutional concerns that would suggest that counsel is needed and necessary, but have like an Anders proceeding, sort of an Anders sort of rule that you could. The client would maintain control. If the client doesn't want to bring a claim, then you would need to abide by counsel's wishes. And if the client wanted to bring a meritless claim, you could file an Anders type brief that said, my client wants to present this claim. I don't think there's a basis for it in the law, and here's why, but this is the claim. What about that kind of procedure that would allow you to shepherd him through? If the client agrees, make the best arguments that you can. But if the client doesn't agree, present no argument, or present whatever argument it is in an Anders type brief that the client wants to present. It's the client's case. It's not your case.
I understand that thought process. What I will say again, and I point the court back to Lambrix and what the court said in Lambrix. And I think that the point is that oftentimes the court is overburdened with pro se defendants filing claims that, like I said, are meritless or frivolous. And even in that scenario, the court would still have to be addressing these claims. And so Lambrix speaks directly to this. And it's exactly the situation of—
I can guarantee you that it would be much easier and much more efficient to address those claims coming from you in an Anders type brief that says, this is the claim, this is the law relating to this area, and this is what my client wishes to present. That would be significantly easier to deal with in most cases than the kind of pro se things that I got when I was on the 5th District Court of Appeal for 11 years.
Counsel, I mean, Justice Lawson is kind of offering you an off-ramp. I mean, your position isn't that, let me just ask it, not rhetorically. I mean, would you prefer Justice Lawson's alternative to the proposal to allow people to represent themselves?
I mean, certainly, I think that if there's a provision that allows us as part of our 3851 or initial briefs or habeas that would allow us to recognize an issue that the defendant wants to raise, that's certainly something to explore. That's not what was presented here. And so I'm not sure that I have explored that thoroughly and what that would look like. And so that's
well,
the best I can say.
I think he's suggesting issues that they wouldn't want to raise, but also a process where the court could hear, to the extent that the petitioner, him or herself, didn't want claims raised that the lawyer is saying they want to raise, then the court could say, do you understand blah blah blah, and if the court is satisfied that the petitioner is making a knowing decision not to pursue those claims, then the client wins, not the lawyer, and the claim goes away.
Well, I think what you're referring to maybe, and I've had this happen where I pled penalty phase mitigation claims, and the client allowed investigation, allowed to develop that claim, put it in the 3851, and then ultimately, when we went to evidentiary hearing, the client wanted to waive that specific claim. That was done against, at my objection. So I think that something that you're suggesting is already in place. They do have that right to waive a claim as long as it's knowing. And the knowing is really the key, because it means that counsel has to have the ability to investigate and provide the entire claim to their client. And so I think what you're saying, Justice Munoz, is really already something that happens. There are scenarios where it's not all or nothing. You waive your entire post-conviction proceedings because you don't agree with what counsel wants to put forth. There are scenarios that they waive a claim. They don't want a claim. They don't want you to put a lethal injection claim in there. Whatever it may be. So that scenario has taken place, and they do have control in that sense of what is being pled.
All right.
If there are no other, I'm sorry, go ahead.
No,
if there are no other questions.
I was going to say thank you.
Yes, thank you.
Thank you. We'll move on to the criminal law section.
May it please the court, Maria Deliberato, and I'm arguing on behalf of the criminal law section of the Florida Bar. The criminal law section's comment opposing the proposed rule change was informed by its capital cases committee, which consists of judges, prosecutors, defense attorneys, law professors, in order to ensure a balanced approach in this very complex area of law. I won't belabor echoing all the comments this morning regarding the logistical and practical challenges, but this widespread agreement among all of these stakeholders does weigh in heavily in favor of this court declining to adopt the proposed rule changes. I want to speak further, and I will certainly address any questions that this court has, and we'll try to follow up on questions that have been asked. But I would like to speak that allowing self-representation, and that was the focus of the criminal law section's comment, though I can certainly touch on the other issues, allowing self-representation in the face of these logistical and practical changes actually rises to a level of violation of due process that's required in these capital cases and does really jeopardize and undermine confidence in the reliability of Florida's death penalty. And this court has recognized that, right? In Gordon v. State, this court recognized its longstanding and solemn duty to ensure that the death penalty is administered in a fair and consistent and reliable manner. And this, of course, comes from the United States Supreme Court itself, which says the Eighth Amendment only allows the death penalty if it can be imposed fairly and with reasonable consistency. Otherwise, it can't be imposed at all. And so, of course, Florida is required in its constitution to interpret, in this court, to interpret its laws in accordance with the United States Supreme Court.
But that right, with all due respect, the right that the U.S. Supreme Court is talking about is a right of the defendant, is it not?
Yes, a right of the defendant to have, well, I mean, yes, but it's also, if the citizens of the state of Florida and of the states that have the death penalty, there's also an inherent duty for victims, for all stakeholders, to be sure that we are administering the death penalty in a fair and reliable manner. It's not just for the defendants.
It just seems so.
I understand that that's has been understood in that way, but I don't know that I see that in what the U.S. Supreme Court has said. But
Yeah, I mean, it seems like your best, the whole, the unreliability and all that seems, then, I mean, that really is an individual thing. It seems to me the more compelling arguments that all the objectors are putting forward is, we're not living in some libertarian paradise where somebody can just make this choice and they live with the consequences and, that's their decision. I mean, they're going to affect the entire system, the victims, the state attorneys, the DOC people, the people who have to be standby counsel, et cetera, et cetera. So it's not one of these deals where someone's just exercising some right of autonomy that's only going to affect them. It's affecting a lot of other people too, in a way that's not, and my personal concern, just speaking for myself, isn't, some concern that somehow their right to a fair review is going to be violated. My concern is what they're doing to everybody else through, the selfishness of, and again, we're not talking about a defensive posture. This is post-conviction, so they're on offense. They've already been found guilty, et cetera, et cetera. They're imposing all kinds of costs on a lot of other people because of essentially for like not because of a constitutional right to self-representation, but because of some kind of commitment to like a policy idea or a philosophical ideal of autonomy.
Yeah, Your Honor, and I think actually that speaks to Indiana versus Edwards from the United States Supreme Court actually speaks to some of that. With respect to the right to self-representation at trial, even that is not unlimited. And it actually talks a lot about that, the dignity and the autonomy, and that's sort of the reason behind these self-representation cases. But there are limits, and there are limits even at trial when doing so would do exactly what you're saying, which is overburden the system, make a mockery of the system, allow for decreased reliability in the process across all aspects. So I think there is precedent for this court to keep the rule as it is, because there is no absolute right to self-representation in post-conviction. It's a completely different standard, as Your Honor has noted. And so there's definitely historical approach and support for limiting that right in a death penalty case. As we've all said, death is different. And so the concern, I think, is that it really could undermine reliability. The way that I was sort of thinking about it and presenting it to the court was, Florida has a unique system of capital post-conviction representation. It's actually very unique among other states. Most states do not require or have an organized system in place of capital post-conviction representation. Our legislature has created the CCRCs, and this court has ratified that system actually to the favor of dismantling it. There was a period of time where CCRC North was closed and it went to the registry as sort of a pilot program. And I mean, a fair look at that, chaos ensued. There was deadlines missed. There was a lot of lawyers who didn't know what they were doing capital work. And this court, and when the Timely Justice Act passed and they brought back CCRC North, was exactly for that, to bring back this reliability, this uniformity in capital post-conviction representation, so that there aren't delays, so that there are, fair and process that goes forward. And so, to me, and speaking on behalf of the comment, that if we go back, if we allow this self-representation, it really will devolve the system into chaos, much like it did when CCRC North closed. And, Florida and this court has authorized this really organized system of capital post-conviction representation. And these rule changes set that back and really put the system at risk of undermining the reliability in the system, which is required if we're going to have a death penalty. I'm happy to talk and sort of answer about the to Justice Lawson's comment about the claims and waiver of the claims and the conversation with Ms. Keffer. I do think that the rule as written is really already allows for that. So 3.851 requires the lawyer to certify that they've gone over the claims with the defendant, that they've explained all of the claims that are being made.
The cases that I've handled since I've been here, where a defendant wanted to represent themselves, what they wanted to do is present a claim that their attorney said wouldn't be a viable claim. And so they want their one chance to present the case that they want in their case, a legal argument. And we say, no, you can't be heard on that. You can have a lawyer, but you can't be heard on that.
And so I think that, again, and like Ms. Keffer, I've been doing this for a long time, and those situations have come up where sometimes we do present a claim to the court exactly how Your Honor described in an Anders style, which says the client very much wants this claim to be raised. This is the law. This is why we don't think it's appropriate. And candidly, some of those claims are a direct result and product of the client's severe mental illness. And that's really what nobody has mentioned as of yet. And I know the commenters mentioned it, and the Mental Health Coalition has commented. The vast majority of the defendants who want to represent themselves have severe mental illness and perseverate into delusional claims. I had a client.
That's a competency issue.
Yes and no. Indiana versus Edwards talks about exactly that, right? So you can be competent to stand trial and also be so severely mentally ill that you cannot, in fact, present your case to the court in a competent manner. I've had clients who had fixed delusional beliefs that all of the experts agreed and that the court and the lower courts have found with respect to cases. I had a client who routinely believed that he was held without counsel and that Gideon versus Wainwright entitled him to automatic release, not just relief, but release. He had 50 years and 5 life sentences in another state. He perseverated on that claim for years. He filed repeated pleadings, and ultimately the court found him not competent to proceed, period. But for a period of time, he was found competent to proceed, but not competent to represent himself for that exact reason. So I think that the sort of hybrid that Your Honor has talked about is actually already in place without making these proposed rule changes. The last thing that I'll say, and then obviously answer any questions with respect to the waiver, I do echo the sentiment of everyone that keeping the direct review of a waiver is critical for this court. This court, again, its solemn duty is to safeguard and make sure that our death penalty is reliable and administered fairly. And allowing this direct review procedure when there is a complete waiver really does support that goal. And the resources, I understand, obviously, anytime a case is before this court, it expends resources with Your Honors and law clerks and the lawyers filing briefs, but they are sort of a rarer appeal process. And I just think that doing away with that really does strip a really important safeguard that I think the federal courts, as they are going to review these cases, as they do review all the death penalty cases in one way or another as it happens, is really that gives them a benefit of a state court finding, of the highest state court making a finding that appeal was knowing and that waiver was knowing and voluntary. I'm happy to answer any further questions. We would, of course, in order to ensure fairness and reliability in Florida's death penalty scheme, we urge this court to decline to adopt the proposed rule changes and to continue to prohibit self-representation and post-conviction and maintain the direct review. Thank you very much.
Right. Thank you very much. Ms. Rowe.
Good afternoon, Your Honors. May it please the court. My name is Laura Rowe and I represent the Appellate Court Rules Committee. It's so nice to see you all again this week. I think it's a rare pleasure that I get to see you all twice in 1 week, but I'm glad to be here and thank you again for letting me appear remotely. Currently, Rule 3851 prohibits a defendant who has been sentenced to death from representing himself or herself in capital post-conviction proceedings, and it also requires that a motion seeking dismissal of post-conviction proceedings include a request to discharge counsel. The court's proposed amendments to Rule 3851B6 eliminate the prohibition against self-representation and the requirement that any waiver encompass both the dismissal of pending post-conviction proceedings and the discharge of counsel. In preparing its comment, the committee considered whether automatic review of such orders is still necessary and appropriate, with a majority of the committee agreeing that it still was. The committee also identified a few concerns with the current amendment language as it's been drafted, specifically regarding the role of discharged and standby counsel in the proceedings. And finally, the committee discussed at length the issue of self-representation for capital defendants, with a majority agreeing that the assistance of counsel benefited defendants, the court, and Florida's capital justice system, but ultimately concluding that whether such a right exists is a legal question for this court to determine. In proposing the amendments that are under discussion today, this court specifically asked whether maintaining the rule provisions providing for automatic appeals when a motion to discharge counsel or to dismiss the capital post-conviction proceedings or both is granted continue to be necessary and appropriate. Ultimately, a majority of the committee, the vote was 29-10, concluded that the rules should continue to provide for automatic review of orders, discharging counsel, or dismissing post-conviction proceedings. However, the committee identified a number of factors for the court's consideration on this issue. In support of the minority position that automatic review is no longer necessary or appropriate, the committee identified two practical factors. One, automatic appeals from orders dismissing post-conviction proceedings and discharging counsel add to the time it takes to resolve a capital case. They take about a year or more to litigate, even with an expedited briefing schedule. And the committee, as a practical matter, did not locate any reported case that in which this court determined that the defendant was actually incompetent to effect a waiver or that the waiver was involuntary. From a more fundamental, or as some other of the practitioners today have said, psychological or spiritual perspective, requiring discharged counsel to continue representing the defendant following an order granting a defendant's request to discharge counsel and finding that the defendant was competent to make that decision would seem antithetical to the defendant's right of self-determination. The minority of the committee members felt that a defendant who succeeds in moving to discharge counsel should be permitted to proceed pro se and to decide whether to proceed with the case at all. Based on some of the comments from the court this morning, I did want to point out for the court's benefit that in such a situation, under Rule 3851I, I think it's sub 8B, if the motion is granted and counsel is discharged, discharge counsel is currently directed to both file the notice of appeal, the notice seeking review in the Florida Supreme Court, and to file the initial brief. However, both the defendant and the state are permitted to serve responsive briefs. So the defendant's participation as a pro se litigant is not totally barred by the current language of the rule amendments. The committee also discussed several factors in support of the majority position that automatic review is still appropriate at this time. Primarily, the committee was persuaded that automatic review currently functions as an important safeguard in Florida's capital justice system. If the decision to appeal is left solely to the defendant who sought the discharge of counsel or the dismissal of proceedings altogether, it's likely that such orders will evade appellate review. A defendant who has obtained the relief he sought is unlikely to voluntarily seek review of the very order granting him that relief. Appellate review of orders determining that a waiver of post-conviction proceedings or of counsel was knowing, intelligent, and voluntary by its very nature, maintains confidence in the reliability of Florida's capital justice system, which, as other participants in today's argument have fleshed out in more detail, could have federal habeas consequences and other concerns down the line in a capital case. But compared to these concerns, the committee ultimately concluded that the resources expended in maintaining the automatic appeals in capital cases were comparatively minimal to the potential consequences of eliminating them. Regarding the proposed language of the current amendments, the committee unanimously approved the amendments to Rule 9.142D1 and 2 as being procedurally consistent with the proposed changes to Rule 3851 and the changes permitting a capital defendant to either discharge counsel or dismiss a post-conviction proceeding consistent with this court's ruling in Davis v. State. However, the committee had a few concerns regarding the proposed language as currently drafted. First, as regarding discharged counsel, the proposed amendments to Rule 3851I and 9.142D both contemplate that discharged counsel will file a notice seeking review and the initial brief. However, if the order to be reviewed does not in fact discharge counsel and only dismisses proceedings, there would be no discharged counsel in order to direct filing the notice of review. That flows into the committee's concerns regarding the language about standby counsel. The proposed amendments to 3851 I9A require the court to appoint standby collateral counsel regardless of whether the post-conviction court actually discharges collateral counsel. Now that we're allowing defendants to choose either to discharge counsel or dismiss proceedings or both, there could be a situation in which defendants choose to dismiss proceedings but not discharge counsel. We believe that this issue could likely be corrected by amending the new proposed language to apply only when a motion to discharge counsel has actually been granted by the post-conviction court. The other issue identified by the committee regarding standby counsel is that once they've been appointed, the role of standby counsel is not defined in either rule set. While discharged counsel is referred to and given some instructions, standby counsel is not. If it's discharged counsel that should file the notice of appeal and the initial brief, and standby and discharge counsel happen to not be the same attorney, it's unclear how standby counsel is going to participate in the following appeal, if at all. The final thing that the committee discussed at length was self-representation. And as my time is drawing to a close, I will just note that a majority of the committee did vote and agree that the support of counsel in capital cases would likely be of benefit to defendants, the court, and the timely resolution of capital cases based on the factors identified by other commenters. We noted especially the comments of the Florida Mental Health Advocacy Coalition and the comment of the Department of Corrections regarding the serious limitations on self-representation for especially capital defendants in the current system as it exists today. If there are no questions from the court, I will conclude, but I'm happy to answer any questions if you have them. Thank you.
Thank you, counsel. We thank all of the participants in today's argument for their arguments and all the other commenters for their participation in this case. That is the final case on today's docket. So this session of the Florida Supreme Court is adjourned.